Mr. Vasquez, sir, can you hear and understand the interpreter?
Señor Vázquez, buenos días. ¿Puede usted oír y entender al intérprete? Your Honor, the interpreter is not sure if he heard me. Shall I repeat?
Yes, please.
Señor Vázquez, buenos días. ¿Me está oyendo?
Sí, sí, lo estoy escuchando.
Okay. ¿Puede usted oír y entenderme?
Sí, sí.
Your Honor, the defendant has responded affirmatively. He can hear and understand me.
Thank you. Mr. Vasquez, my name is Brad Gardner. I'm a judge in Magistrate Court of Clayton County.
Señor Vázquez, yo soy el juez honorable Brad Gardner. Soy un juez aquí en el Tribunal Menor en la sala menor del Tribunal de Primera Instancia del Condado de Clayton.
This is your first appearance hearing. We're not here to take a plea in your case or to have a trial of your case.
Esta audiencia es su comparecencia inicial. No estamos acá para que usted se declare ante acusaciones, tampoco para llevar su caso a juicio.
We're here for me to tell you the charges that have been placed against you.
Estamos aquí para informarle de las acusaciones formuladas en su contra.
To tell you of any future court dates.
Para informarle de las audiencias futuras que están programadas.
To see if you will require the assistance of an attorney.
Para determinar si usted requiere el asesoramiento de un abogado.
And to give you some basic understanding of your rights.
Y también para explicarle básicamente lo que son sus derechos.
You've been charged with one count of pedestrian in the highway.
A usted se le están acusando de una infracción de peatón en la vía de tránsito.
And that basically means that you were seen crossing a roadway not in a crosswalk.
Eso significa básicamente que a usted lo observaron cruzar una calle fuera de la zona peatonal.
The bond for this offense, Mr. Vasquez, is $500.
La fianza para esa infracción, señor, es $500.
You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning.
Su audiencia preliminar estará programada para el 8 de noviembre a las 8:30 de la mañana.
That date will get waived upon your bonding out, and you'll get a new court date in the mail.
Esta audiencia quedará renunciada una vez que usted salga en libertad bajo fianza y recibirá la notificación de su nueva fecha de audiencia por correo.
Before I tell you a little bit more, would you like for me to see if you qualify for the appointment of a lawyer?
Antes de decirle un poco más, señor, quiere que yo determine si usted reúne los requisitos para un abogado de oficio.
Sí. No sé.
Yes.
No.
I'm going to appoint a lawyer to represent you, Mr. Vasquez.
Señor, le voy a poner un abogado de oficio para que lo represente.
Now, as it relates to the bond, you can post bond in one of three ways.
Ahora bien, señor, en cuanto a la fianza, puede pagar la fianza en una de tres maneras.
The first way will be using a bonding company.
La primera manera sería tramitar la fianza a través de una compañía de fianzas.
You will pay a fee to that company, which is normally a percentage of your bond.
Usted pagará una tarifa a la compañía que suele ser un porcentaje de la fianza total.
The fee that you pay to that company will not be returned to you.
Y la tarifa que le paga la compañía no se le devuelve.
You can post the entire amount in cash to the sheriff's department.
Puede depositar la fianza total en efectivo en la comisaría del sheriff.
The sheriff's department will hold that money and then return it to you when your case is over.
La comisaría del sheriff guardará el dinero y luego se lo devolverá una vez que se ha concluido su caso.
If you have property within Clayton County that has a value of at least 3 times the bond amount, you can use that property as collateral for your bond.
Si tiene una propiedad con un valor adquirido por lo menos 3 veces lo que es el valor de la fianza, puede usar como garantía esa propiedad para la fianza.
The sheriff's department will place a lien on that property and then remove the lien when your case is over.
La comisaría del sheriff impondrá un gravamen en esa propiedad y luego le quitará el gravamen una vez que se concluye el caso.
Now, this is where I tell you of some of the rights that you have.
Ahora, este es el momento que le explico a algunos de los derechos que tiene.
During this and all other proceedings, you will have the following rights:
Durante esta diligencia judicial y cualquiera en el futuro tendrá los siguientes derechos.
to the presumption of innocence,
Tendrá el derecho a la presunción de inocencia,
to indictment by a grand jury for most felonies or by accusation for misdemeanors,
el derecho a que se le emite una acusación formal por medio del gran jurado cuando se tratan de delitos graves o que proceden en su contra por medio de acusación general cuando se trata de delitos menores.
to a speedy and public trial by jury,
Tendrá derecho a un juicio público y sin demora ante un jurado.
to see, hear, and question witnesses who are called to testify against you,
Tendrá también el derecho de ver, a escuchar y a contrainterrogar los testigos convocados a declarar en su contra.
to compel the attendance of witnesses to testify on your behalf,
El derecho de obligar la comparecencia de testigos para que declaren a su favor.
to testify on your own behalf or offer evidence in your own defense,
El derecho de declarar en representación propia o presentar pruebas para su defensa.
and you have the right to have an attorney represent you.
Y también, señor, tendrá derecho a un abogado para representarle.
And in your case, I have appointed an attorney to represent you.
En el caso suyo, ya designé un abogado de oficio para usted.
Do you have any questions for me, Mr. Vasquez?
¿Tiene usted alguna pregunta para mí, señor Vázquez?
No, es todo.
No, that's all.
Okay, sir, you're free to go back.
Échale 8
Muy bien,
días.
señor. Your Honor, you said that my court date is the 8th of November.
Yes, sir, but if you bond out, that date will get waived and you'll get a
Sí.
new court date in the mail.
Sí, señor, pero si usted deposita la fianza y sale, entonces esa audiencia quedará renunciada y le notificará por correo de la fecha de la próxima cita judicial.
Okay, sir?
¿Está bien?
Está bien.
That's fine. Okay.
Okay, sir, you're free to go back.
Muy bien, señor. Ya se puede retirar. Gracias.
Thank you, Ms. Tolles.
Thank you so much, Your Honor. I hope you have a great day.
I hope you have a great day.
Take care.
Goodbye. Okay, let's switch over to the ladies. Well, no, let me read the script for everyone. I need everyone to stand up. Okay, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, would everyone please raise your right hand? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God? Okay, now let's begin on the ladies' side with Miss Bourque, Bourque. Miss Bourque, ma'am, you're charged with one count of simple battery. This is a misdemeanor offense. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Aaliyah Tyree, and Aaliyah, A-L-E-Y-I-A, Tyree. Do you understand that, ma'am? Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I wanted to ask the commercial. I kind of heard a little bit of it. The commercial, that's where you did the percentage of the.
Yes, ma'am. And I'll explain it to you. And it's fine to ask questions. That's what I'm here for, to answer questions. So you got three options in how to post a bond. One is what we call commercial bonding, and that's generally known as a bonding company. Okay. So I think there are 5 or 6 bonding companies that are authorized to write bonds here in Clayton County, and you can go to either one of them. I encourage you to see all of them, because each one will quote you a different fee. Whatever fee they quote you is generally based upon a percentage of your bond, and it's generally about 10 to 12% of your bond. Whatever you pay to them as a fee, that stays with them. They will not return it. You can post the entire amount to the sheriff's department in cash, and the sheriff's department will hold that money. And then when your case is over, they'll return all of the money to you. Finally, if you have property, real estate that has at least 3 times equity of the bond amount, you can post that property. Sheriff's Department will place a lien on that property. And then when your case is over, they will remove that lien and you can go about your business. Okay. Any other questions, ma'am?
I noticed that you said that I can talk to those bonding companies. How would I go about that part?
So there should be a list, and I've seen it before, but I don't know exactly where it is. You could just ask one of the deputies and they'll direct you. But generally, there's like a little slip of paper that has the bonding companies, their names and the telephone numbers. Or when you get the opportunity, I don't know if you've had the opportunity to speak to any family members yet, but if you have the opportunity to speak to a family member, it may be easier for that family member to make the phone calls, because they can just sit and make the calls. You may not necessarily have that amount of time on your hands, but you now know what the bond amount is. And I just have to caution you that it's going to be a little bit higher than the $4,000 because the sheriff's department is required by law to add certain fees, but they have the fee schedule and I don't. So because they have the fee schedule, whatever bond I set, they add the fee to it based upon the schedule that they have.
Okay. And just to make sure, even though this is my first offense, it's going to be set that high. Okay.
Even though it's your first offense, it's going to be what?
I said, so even though this is my first offense, it's still going to be set that high to 4,000, correct?
Ma'am, this is what I set every simple battery to, and I'll tell you the reason. You have a choice of what you do with your hands. You have a choice of what you do as it relates to other people. You can't imagine how many batteries I see in a week because people get into arguments and they decide they want to fight each other. We just don't have the resources to have law enforcement coming out to referee fights between adults when people are getting shot and their doors are getting kicked in. And we need those law enforcement officers there rather than at your house. Does that make sense to you? So the next time that there is a disagreement, hopefully a cooler head will come about and somebody will leave and go drive around or whatever, as opposed to thinking that we're going to tie up resources because we have a disagreement. Okay, so that's the public policy behind it. Okay, anything else, ma'am?
No, that's all.
Okay, ma'am, you're free to go back. Miss Crankshaw.
Yes, sir.
Miss Crankshaw, ma'am. Okay. This is your third charge as with an allegation of driving under the influence of alcohol, which means that it makes this a felony offense. And with respect to that, the bond goes up. And I see that you're not working. Are you, and I'm sorry if I do not mean to offend you by asking this question,
No.
but are you retired or is it you're just not working or what's your?
I'm retired. My husband died 10 years ago, and I really had no problems before that, but not that that's an excuse, but
I understand.
no, I'm not working. I live in a government Section 8 facility, and so I'm able to live on a small Social Security check, and it's small. It's less than 700 right now, because I worked for private schools more than public,
I understand.
and they didn't pay in the Social Security. You know, they didn't take it out, so I didn't get it back.
Right. Okay. This is what I'm going to do, ma'am. I'm going to set your bond at $5,000, which is the amount that I would normally set for a first time DUI. But it's still going to remain a felony offense. So you're charged with DUI as a third offense. That's a felony. I'm going to set the bond at $5,000. You're charged of following too close. I'm going to set the bond at $500. And you're charged with an open container violation. I'm going to set the bond at $500. You may want to consider entering the DUI treatment program. It looks like that you have been assigned to that before out of Noonan.
Yes,
Are
sir.
are you still in that program, ma'am?
No, but may I ask you a question?
Yes, ma'am.
I don't know where, but I've heard places where you can go to get help and stay there, or either if you consider that.
Well, I can't order that here at first appearance. What I can do is I can appoint a lawyer to represent you. Do you want me to do that?
Yes, sir, please.
Okay, I'm going to appoint a lawyer to represent you and speak to the lawyer about your situation, because they will most likely be able to work something out fairly quickly to move you into a treatment facility. But there are going to be things that you're going to have to agree to, but that'll be a discussion between you and your lawyer.
Yes.
And as it relates to where it goes with the district attorney's office, they're going to have to agree, of course, but that's where this becomes an issue of negotiation and discussion, as opposed to having an adversarial stance. Because this is a felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions for me, Ms. Cranksaw?
I think I asked the only thing that's all I can think of right now. Thank
Okay.
you.
You're welcome. Stay in contact with your lawyer, ma'am, and I wish the best for you.
Thank you.
Okay. Let's bring up Ms. Davis. Ms. Davis, ma'am, you're charged with one count of terroristic threat as a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a
Thank you so much.
You're welcome. There's going to be a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, ma'am, you're free to go back.
Thank you again.
You're welcome. Miss Finn? Miss Finn, ma'am, you're charged with one count of simple battery as a misdemeanor and one count of giving a false name, address, or date of birth to law enforcement. These are both misdemeanor offenses. For the simple battery, bond is going to be set at $3,000. For the giving false name, address, or date of birth, bond is going to be set at $2,000. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay,
No.
ma'am, you're
Thank
free.
you.
You're welcome. Ms. Trotter,
Yes, sir.
good morning, Ms. Trotter.
Morning.
Ma'am, you're charged with one count of knowingly driving a vehicle with a suspended registration. Bond is going to be set at $500. That's a misdemeanor offense. One count of driving a vehicle with no insurance. Bond is going to be set at $1,000. And one count of driving a vehicle with a canceled license. Bond is going to be set at $1,000. Because these are all misdemeanor offenses, you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like me to see if you qualify for a lawyer, Ms. Trotter?
Yes, please.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I'm not.
Okay, ma'am, you're free to go back. All right, is that the last person we have on the ladies' side?
Yes, sir.
Okay, thank you. Let's switch over to the male side, Mr. Banks.
Yes, sir.
Mr. Banks, sir, you're charged with one count of possession of firearm by a convicted felon. I have a concern, Mr. Banks.
Yes.
It looks as though you've had a number of recent arrests in Atlanta. It looks like you were arrested on August 8th of this year. Possession of firearm and knife during the commission or attempt to commit felonies, aggravated assault, receipt of possession, transport of firearm by a convicted felon. Because of that August arrest, I'm going to deny bond at this time on this offense. And this is going to give at least your lawyer or to give a little bit more perspective to see whether you should remain in custody or whether you're a person that is a good candidate for being out on bond. Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. I'm going to set a bond hearing date for November 11th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. And I don't know. Let's see. So it looks like I'm going to be doing the preliminary hearings that week. And so you can tell your lawyer that the one thing that I want to know is the status of your case in Atlanta, that August arrest.
I'm just out on bond for it. They haven't the victim told my public defender and the judge that day I went to court that it wasn't me and it don't look like me. The person that shot at her. And she
Okay.
was on my behalf at court, everything recorded.
Okay. Well, that's the kind of stuff that I want to have a better understanding of, because you do have a little bit of a history, and it does point towards violence related issues. So one of the things that I have to be concerned about is public safety, and having this type of weapon in your possession and seeing.
It wasn't in my possession though.
Sir. Possession can be constructive or actual. They're alleging constructive,
All right, I
meaning,
apologize.
okay, meaning they're not saying you're busting out of the house with a gun in your hand. That's not the allegation. Allegation is that this weapon was in a place where it could reasonably be assumed or presumed that you had some kind of custody or control over it. Those are the things that are going to have to get worked out. And I'm just being honest with you so that you can have a conversation with your lawyer. And so when we show back up on the 9th, everybody's ready to go.
All right, thank you, sir.
Okay. All right. You're free to go back.
All right, thank you.
You're welcome, Mr. Bennett. Mr. Bennett, sir, you're charged with 1 count of simple battery. I'm going to set the bond at $3,000. You're charged with 1 count of criminal trespass. I'm going to also set the bond at $3,000. These are both misdemeanor offenses. So you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Now, there's going to be a stay away provision on this bond to stay away from a Maya Bennett. And I understand that that's a relative, correct?
Yeah,
Do you all stay in the same household?
yeah.
Okay. Well, that's going to have to be something that for the short term, it's going to have to get changed unless you go through the Solicitor General's office. And if Amaya Bennett says, hey, I don't have any problems with this person being under the same roof, then, you know, they can petition the court to modify the stay away provision. And 9 times out of 10, that happens. But just so you understand, whatever disagreement that led you to come before me today, you're going to be able to bond out today. And we don't want that to flare back up at night. Okay.
Yeah.
Do you want me to see if you qualify for the appointment of a lawyer?
Time?
Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Not at the moment, no.
I'm sorry, sir.
No.
Okay, you're free to go back. Mr. Gray. Mr. Gray, sir, good morning, sir. You're charged with 1 count of possession of Xanax pills. That's a felony offense. I'm denying bond on that at the moment because it appears that you're still on probation. You're charged with 1 count of driving on a suspended or revoked license. Bond is going to be set at $1,500. You're charged with 1 count of possession of a firearm during a crime. That is also a felony offense that I can't set bond because it appears that you're still on probation. And so, Ms. Wesley, that's no bond pursuant to 17-10-1 for both of the felony offenses. And then you're charged with 1 count of a tag obstruction, and bond is going to be set at $500. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That will be most likely by Zoom. I'm also going to set a bond hearing date for November 11th at 8:30 in the morning. That will also be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I just got a quick question. Just real fast. Basically, as far as on my probation, I'm on non-report, and I actually don't have an actual assigned
Probation officer.
Yes, sir.
So,
So how would I go by as far as me letting my family know to contact somebody from, you know?
So suspended sentences and non-reporting probation both count as being on probation.
Right.
So if you're trying to get this matter taken care of as quickly as possible, there should be like a last office. I mean, is it non-reporting out of Clayton County, non-reporting out of Fulton County? Where is it non-reporting out of?
I was actually assigned out of Fulton, but I got transferred to Clayton. So this was like around COVID time. So I wouldn't say my last time reporting was probably like 4 or 5 months ago, something like that. And then that's when I got put on non-report and haven't spoke to anybody since then. I don't have a sign officer or anything.
So you most likely will need to contact the probation office here in Clayton, but have that conversation with your lawyer, because I'm telling you what I believe, but the lawyer will tell you what the lawyer knows. Okay. And that's the best that I could give to you. Okay. Anything else, sir?
No, that's it.
Okay, you're free to go back. Mr. Jarrett.
Good afternoon, y'all.
It's still morning. I'm working fast.
Good morning. I'm sorry.
Thank you, sir. Mr. Jarrett, sir, you're charged with 1 count of possession of a firearm with an altered serial number. That's a felony offense. I'm going to set the bond at $5,000 for that. You're charged with 1 count of misdemeanor possession of marijuana less than an ounce. I'm going to set the bond at $1,500. And you're charged with 1 count of loitering or prowling. I'm going to dismiss that count. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. I just want to make sure the total amount for my bond was $7,000 altogether, correct?
$6,500.
All right, thank you.
But again, it'll be a little bit higher because the sheriff's department is required to add fees.
Yes,
to the
sir.
bond. Okay. All right, sir. You're free to go back.
Thank you.
You're welcome. Mr. Pride. Mr. Pride, sir, you're charged with 2 misdemeanor counts of terroristic threats or acts. I'm going to set the bond at $4,000 for each of those counts. And you're also charged with 1 count of simple battery. That's also a misdemeanor. I'm going to set the bond at $3,000. There's going to be a stay away provision on the bond, to stay away from a Robin Taylor and a George Taylor. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Can you repeat my
It's $11,000 without the fees added on is your total bond. Any other questions, sir?
No, sir.
Okay, you're free to go back.
Thank you, sir.
You're welcome. Mr. Proctor. Hold on one minute, sir. I'm sorry. Mr. Proctor, sir, you're charged with 2 misdemeanor offenses. One is driving a vehicle with no insurance. Bond is going to be set at $1,000. And the second count is having an open container violation. Bond is going to be set at $500. Because these are both misdemeanors, you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh,
Okay. Do you have any questions for me, sir?
no, I'm good.
Okay. Have a good day, sir. Mr. Skillings. Mr. Skilling, sir, you're charged with one count of affray. This is a misdemeanor offense. Bond is going to be set at $1,000. You're also charged with one count of public drunkenness. This is also a misdemeanor. Bond is going to be set at $1,000. Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, Your Honor.
You said no?
Yes. No, Your Honor.
Okay, sir, have a good day. You're free to go back.
May I ask you a question?
Yes, sir.
Can you explain to me what a fray is?
Affray is basically fighting in public. So if I were to attack you, that could be a simple battery or a battery. If you and I agree to engage in a fight, then that's a fray. So it's not saying that one person caused the fight versus another. It's saying they both agreed to fight. And if it's in public, it becomes a fray.
May I ask you one more question?
Yes, sir.
Is there any possibility I could get a signature bond?
No, sir.
All right. Thank you, Your
Okay.
Honor.
You're welcome. Mr. Enrico Thomas. Good morning, sir. Mr. Thomas, you're charged with one count of disorderly conduct. That's a misdemeanor offense. I set the bond at $1,500. You're charged with one count of obstructing an officer. I set the bond at $3,000. And you're charged with one count of possession of marijuana more than an ounce, which is a felony offense. And I'm denying bond at this point because it appears as though you're still on probation. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. You're going to also have a bond hearing date set for November 11th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, you said the bond was 4,500.
Yes, on the misdemeanors.
Okay. But the felony, what did you say about reaching somebody? Because my disposition is actually it ends tomorrow.
I saw. I mean,
Yeah.
you're that close.
They said don't explain, so I mean it's not really gonna matter.
No, don't explain. But I'm gonna say this to you, Mr. Thomas. From what I read, this was something that was totally avoidable.
Yeah, dealing with my mom, like I was just protecting my mama. That's all. She called me and I came.
I understand, but I'll say this. Somebody should have said, hey, he's on probation. He's about to get off. Let's let this ride for 5 days and then come back and address it. But my hands are tied. Now, the way the statute works is this. I can't set bond at this stage. Doesn't mean your lawyer can't get with the district attorney's office tomorrow, day after tomorrow, no, Monday or whenever, and they reach an agreement. They do what they call consent waivers, consent bonds, consent bindovers, all of this stuff to move the case along, and you get a benefit where they agree to setting a bond on this. So speak to your lawyer about it, especially about the facts and circumstances of your case, and the lawyer may be able to work something out that gets you out of here very shortly.
So you said have somebody reach out to my PO and let them, what did you say?
So two things. Your PO can contact the DA's office and say, hey, this person has been fined. I don't have any problems with this person. If y'all want to put this person back on the street, I'm not going to place a hold on them. Your lawyer may go to the district attorney's office and say, these are the facts and circumstances that led to my client's arrest. We're willing to work something out on a short term so that he can get a bond and get back out on the street, and then we can deal with this later.
Okay, so I got one more question. Let's say if I get my folks to reach out to the PO or something like that, and they decide not to put a hold on, when would I won't get a bond until my next bond hearing for that felony?
No, and that's why you need to speak to your lawyer, because the lawyer is the person that can advocate on your behalf between the probation officer and the district attorney's office. Okay, so if your folks theoretically call your PO, first thing the PO is going to do is say, well, I got to figure out what happened. And that may take a week. It may take 2 weeks. And then we're back up. I see you again while your PO is still trying to figure out what happened.
I mean, but by then, probation will be terminated. It will be over.
So this occurred prior to your probation being terminated. That's why you're being held. So it doesn't just fall away.
No, correct.
Okay. So just speak to your lawyer and start with your lawyer. I'll start your lawyer. Okay, sir.
They'll be in touch as soon as when? Or I have to wait till that? Or they'll just
so my understanding from what I've seen is that they set up video visits. So they'll arrange through the jail to have a date and time to speak to you. So make sure you pay attention to that and that you're on that call, because that's when they can get the most information and get started. Okay?
the bond is $450 for the 2 misdemeanors.
Yes, sir.
All right, thank you.
You're welcome. Mr. Williamson. Mr. Williamson, sir, you're charged with 1 count.
Oh, shit.
Mr. Williamson, sir, this is being recorded and you are in court. Okay?
Yeah.
Thank you, sir. Mr. Williamson, you're charged with 1 count of forgery in the 3rd degree. This is a felony offense. I'm setting the bond at $5,000. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Although, let me see. No, okay. For some reason, I thought that there was a warrant showing for you, but it's not. That November 9th date at 8:30 in the morning will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. And finally, we have Mr. Charles Anthony Thomas.
Hello, good morning.
Good morning, Mr. Thomas. Sir, first, I want to tell you that all of the rights and privileges that I discussed earlier, they apply to you in this context also.
Okay.
You are in sort of a special situation where the language is called being a fugitive from justice. And what that simply means is that there's a warrant for your arrest out of another state.
Mhm.
And in this situation, it appears that it's Arapahoe, Colorado.
Yeah, Arapahoe.
Arapahoe,
Arapahoe, yes.
Colorado. Okay. For contempt of court for failure to, it says comply. And there is a warrant number. I can give you the warrant number if you want the warrant number.
Yes, may you spin, please? Thank you.
Okay, the warrant number is W06. Wait, I'm sorry. Yes, 060605.
060605.
Yes, sir. 710.
Okay, I'm gonna repeat that to you one more time, sir.
Okay.
0606057110.
Yes, sir.
Okay, cool.
So, being in this status, you have a right to challenge the extradition because they said that they're going to come and get you. If you were to challenge the extradition sometime between now and the next 90 days, there will be a hearing to determine whether you are the person named in the warrant and whether the warrant actually evidences or shows that this is a charge that is a valid charge. If at the end of that hearing, the judge determines that you are the person named and that the charge is a valid charge, the judge will sign off on a writ. And sometimes it's called a governor's writ or different names for it. But the writ will then allow Colorado to come and pick you up. So from the date that the judge signs off on the order, there is a minimum of 30 days, maximum of 60 days that Colorado has to come and get you. The statutory period is 30 days. It could be sooner or it could be up to the 29th day. If Colorado decides, hey, we want to apply for an extension and that extension is granted, there's an additional 30 days added. If Colorado does not come and get you, then the sheriff's department will release you out of the front door, but the warrant is still valid. So you can walk out the front door. I'm gonna let you speak. Walk out the front door. 5 minutes later, you interact with another law enforcement officer. They run your information. They say, hey, you got a valid warrant. They take you back into custody. It starts all over again. Now, I interrupted you. Go ahead.
Okay, so what I was going to ask, so the second, after they file for the first extension, if they don't come pick me up that second time, then I get let go after 60 days.
Yes, sir.
Okay, all right. And then if I don't sign the extradition, then I'd have to wait up to 3 months to challenge this?
Yes.
Okay, cool.
Now, hold on. Oh, go ahead. I'm sorry.
So my next question was, I had it in my head. I'm so sorry. Do forgive me. So when was the warrant issued? What day was it issued? Do you have that information?
I do not have that information. It probably is within the the files of the fugitive squad at the sheriff's department.
Okay.
Sometimes they'll have a date listed and sometimes they won't. In this situation, they don't have a date issued or listed. But
Okay.
now, today, you can decide to waive the challenge. If you
Mhm.
believe you are the person named and you believe that possibly this warrant does exist out there, you can waive that. It doesn't mean you're guilty. You waive the right to challenge it. And that 30 to 60-day period starts to run today.
Yeah.
And so what I generally tell people is, one, no matter what, you need to get you a lawyer out in California. I mean, California, out in
Colorado.
Colorado to represent your interests out
Mhm.
there. Because of the whole COVID stuff and people not wanting to travel and things like that, I've seen where someone hired a lawyer and the lawyer was advocating on their behalf in it's called the requesting jurisdiction, meaning Colorado in this instance. Get into contact with the district attorney or the prosecutor or the judge out there, and I say, you know what? Because this person has hired a lawyer and because this person is taking these steps, we're going to grant a bond. I can't grant a bond, but they can grant a bond. And if they grant the bond, they transmit that information to us and we release you out the front door.
Okay. All right. So the thing about why this is kind of funny to me is I've been here for the past 3 years. I haven't been out in Colorado since 2019. So I'm a little confused as to like why all of a sudden there was a warrant for my arrest. So I was trying to get the timing of it, at least when the warrant was issued, so I could at least tell my somebody that, hey, like I've been in Georgia for this amount of time. So I don't know how I could have gotten this charge.
Let me ask you this. Were you in Georgia on a charge that recently got resolved? Were you in Clayton County on a charge that we call it disposed of, meaning it was either dismissed or you pled guilty to something?
Yeah, I've been to Clayco. It was for driving on a suspended license. That was also 3-4 years ago.
And you've been in custody since then?
Have I been here since then? No.
Okay. So generally, and I'm not gonna ask you to get into your details because this is being recorded. Generally, if there's a warrant for your arrest and out of another jurisdiction, and you are arrested on new charges, that warrant sits until whatever the new stuff that you have has been resolved. And then once the new stuff gets resolved and you're ready to walk out the door, that's when the warrant hits. So I don't know, and I'm trying to look up your situation. Let's see. So it looks like you had something in DeKalb. Were you in custody in DeKalb?
When?
It says 2014, 2015, looks like it was accused, meaning formally charged. And then it says 2019, you were arrested on driving while license is suspended or revoked.
Yeah.
And says you were sentenced to 12 months of a suspended sentence. So have you been out of custody during any of this period of time?
Yeah, I've been out of, I've, yeah, I've been out of custody. Yes, I haven't been in jail, no.
Okay. So it looks like it says the date of the warrant was October 14th of 2022.
That's when they issued the warrant. Wow, okay.
Yeah.
Can you repeat that for me, sir? You said October,
October 14th of 2022.
so it was issued just a couple of weeks ago.
Yes, it says Sheriff's Office of Centennial, Colorado. Does that make any sense to you?
Centennial, that's where Arapahoe County Jail is at.
Okay. So I don't know. But it looks like it says I don't know. It says failure to comply. I'll give you, it looks like there's a case number. It says 2019-3056.
056. Okay, case number is 2019-3056, correct?
Yes.
Excellent.
Okay, so do you know what you want to do? Because it's the choice is yours, either to contest this or to and get a lawyer to represent you out in Colorado.
So when I was out in Colorado, I was in jail out there. And I had a lawyer that was helping me with my situation out there, and my mother has gotten in contact with him. So I guess hopefully he's going to do some things on my end. Do I need a lawyer for this side as well, or just for that side?
Just for that side.
Okay, all right, cool. I know there was another question I had. Do forgive me, I'm so sorry, Your Honor. Okay, so just to review my choices again, if I sign this now, then either at maximum I can remain in here 60 days, and as long as I don't get caught up in anything else, then I can be on the outs until Colorado either sends me something or says I need to come out there, right?
Right. And one of the things that you may want to consider, and let me have this conversation with your lawyer, is that if you waive the hearing, the clock starts to run now for Colorado to come and get you.
Okay.
So that may give your lawyer extra leverage in working something out, because they know that if they don't, they're going to have to send somebody down here to get you.
Okay. And then in the case that I decide to fight this, do forgive me for cutting you off. I'm so sorry.
No.
In the case that I decide to fight this, it'll be a month to potentially how long before I could squash this?
See, and that's the thing. I couldn't tell you. You would get placed on a calendar, and I know that. I can't tell you when that will happen, but there is a statutory time limit for us to place you on a calendar also. But if you were fighting it, theoretically, Colorado has an extra 90 days to decide what they're going to do.
Okay, so beyond the 30 days for just signing, they'd have another 2 months on top of that 1 month.
Yes, sir.
Okay, all right. Yeah, I'll sign the waiver, and I'll get a hold of somebody on that end to make sure that I have a lawyer on that side.
Okay, no matter what, make sure you hire a lawyer out in Colorado to address this, because it appears that it's not, it's not like it's a murder warrant. It just seems like there's some kind of technical issue that may be able to get worked out.
Yeah.
Okay.
Yeah, going out there is what I got to do. That's not an issue.
Okay.
Is there any more? I'm sorry, sir. Is there any more information that any case numbers or any other things that I could possibly look up?
No, that's what I see.
Okay, cool. Thank you.
So
So,
I can do, there's a number for the sheriff's department if you want that.
yes, please, that would help.
It's 303
303
795
795
4711.
4711, Sheriff's Department, Arapahoe. All right.
Any more questions, Mr. Thomas?
I can think of at the moment, sir.
Okay, have a good day.
Oh, I'm sorry, sir. So should I go ahead and sign this? Because I did want to sign it.
Yes, go ahead and sign it and give it to the deputies and they'll send it to me and I'll sign it. And the clock will begin running today.